Hello and welcome to another TDW Tech Bite. Today I'm going to talk about the Schrems II. The Schrems what? The Schrems II. That's a judgment of the European Court of Justice, and I'm going to explain how that impacts on the lives of data importers in Hong Kong who are receiving personal data from data exporters based in the EU. Now you might think, a European Court of Justice decision. Why is that important here? Well, the reason is one of the bases on which personal data is exported from the EU to third countries outside of the EU is by relying on appropriate safeguards embodied in standard contractual clauses that have been approved by the EU government bodies. Now, those standard contractual clauses have been put into many contracts that are in force in Hong Kong, regulating how data importers in Hong Kong are handling that personal data. The Schrems II judgment looked at that, which means that contracts that are being relied upon and used in Hong Kong are now going to be under a new kind of scrutiny and assessment, and that could impact on you. So let's speak about Schrems II and what it is about. It all goes back to Edward Snowden. Do you remember that American gentleman who transited through Hong Kong on his way to Russia as he gave details of mass surveillance programs that were undertaken by US authorities like the FBI and the NSA? Well, Schrems II came out of that. Maximilian Schrems, an Austrian national, made a complaint to the Data Protection Office in Ireland, no less, looking to prevent his personal data being transferred by Facebook from the EU to the US. The basis of that request to prevent the transfer was because of the uncertainty of the security status of that personal data from access by public authorities, such as the NSA and the FBI in the US. So the European Court of Justice looked at the mass surveillance programs undertaken by public authorities in the US and has handed down a decision. That decision has a number of overarching principles and ramifications. We're going to look at what is relevant here in Hong Kong only. Now, one of the reasons on which parties who are transferring personal data from the EU to third countries, one of the bases on which they choose to do so is by trying to provide appropriate safeguards in their contracts in respect of the protection of that personal data in the third country. Those standard contractual clauses have been signed off by the European Commission, and people felt comfortable relying upon them. Of course, they needed to implement them fully and effectively in how they operated their contract, which would have involved an assessment of the programs that they had in place before signing off on the contract and a management program in the course of performing the contract. But now there's a third element. Not only must you assess the compliance or the ability of the contracting parties to comply with the terms as written, you also need to assess the laws of the place of the data importer to ensure that those laws provide EU levels of data protection in the context of data access requests by public authorities. So what does that mean in Hong Kong? That means you need to assess whether the safeguards within our new national security law are still consistent with EU levels of data protection in respect of access requests by the national security authorities in Hong Kong. Now, this is a brand spanking new piece of law, and it is something that is pretty hot off the presses here in Hong Kong. We don't really know yet how the national security law is going to be interpreted, enforced, and applied. It's still just barely over a month in existence. So there is a certain element of watch this space. And if you were to look just in terms of the text of the laws and you were to compare to the equivalent laws that were in the US, basically Hong Kong's got a mixed report card. Some aspects are a bit better, some aspects are not as good, or at least as bad as the US position. So where we are in respect of EU level equivalence and assessing the national security law is certainly open to debate. Unfortunately, that debate is something that is going to be pressed and pushed along the contractual line to Hong Kong-based data importers, because EU data exporters, they will not know about the comparison and contrast of the Hong Kong national security law to EU laws. They're going to look to the data importer to provide that kind of guidance. And so you might find a situation where Hong Kong data importers are asked to respond to assessment inquiries during the diligence phase for contracts, which require them to give views and opinions on the equivalence of the national security law to EU equivalent laws and protections. That's something that contracting parties, data importers, are not really equipped to do themselves. They'll need to go to lawyers to help them, perhaps, and even lawyers might struggle to provide definitive guidance in the early days of that legislation. Also, Hong Kong data importers will need to be careful that they're not requested to give undertakings to refuse access requests by public authorities in Hong Kong, because, well, the law is the law. You can't say to the national security authorities here that you're going to refuse an access request that has been lawfully made in compliance with the national security law. That's simply not possible. So you could find yourself either in breach of contract or in breach of the national security law. That is the definition of being between a rock and a hard place. Now, there are some areas where you can start working on a resolution and a path forward to this particular issue right now. You can start looking at other aspects of either ways of achieving appropriate safeguards under GDPR, or you can look at ways of using supplementary measures to try and mitigate the impact of this ruling. So what are some of the alternatives? You could look at perhaps the data exporter getting the consent of the EU nationals and data subjects in the EU to the transfer to Hong Kong. Now that consent would need to be expressed, would need to be specific, as in specific relating to the data transfer, and would need to be voluntary. So these are quite specific requirements. And also the downside is that consent can be withdrawn, so it can be taken away from you. You could look at maybe looking at binding corporate rules, but the process for that might be a long-term solution. That is not something that is going to be implemented today or tomorrow in respect of any organization, because it needs an entire process that is overseen, signed off, and approved by a data protection authority within the EU. Some supplementary measures that you can look at is good old-fashioned data minimization principles. Only transfer or receive into Hong Kong the personal data that is required for the processing activity that needs to be conducted here. Don't take more than is necessary. And by adopting this kind of approach, well, if you don't have the data, it can't be subject to an access request by a public authority. You could look at data anonymization in respect of data that can be anonymized in the context of the data processing activity to be conducted here. That's another way of minimizing personal data access requests in Hong Kong. And thirdly, you could look at encryption, which should be there in respect of data in transit in any event, but you can make sure that that is the case in respect of personal data on its way to Hong Kong. All of this is early days and knee-jerk reactions to what is quite a landmark and extensive, profoundly impactful decision from the European Court of Justice. Just because it was handed down in Strasbourg, a long way away from Hong Kong, does not mean it hasn't an impact here. And it is surprising to think that the revelations that Edward Snowden made 8 years ago are still having these repercussions now in Hong Kong, the place he visited on his way as he was leaving the US. The more that time passes and things change, the more they sometimes stay the same. That's all for this TDW Tech Bite. Tune in next time for another update on technology in Hong Kong.